The board education agenda. We have two items on our agenda for training this afternoon, our annual fiduciary duty training and annual ethics. So we'll let Ian kick us off with our annual fiduciary training. Good afternoon, Ian.
I think everybody on this board has heard me before, so I'm not going to, I don't remember if Rich did. I'm going to try not to repeat myself too much, but some of the things I guess have to be said in the record, so you could say you've been trained. But one thing I am going to do this year, I don't know if you had a chance to look at the slides, is I'm going to go into the weeds a little bit, which is something I've avoided in the past, talking about economically targeted investments, or ETIs, because it seems, last couple of years, we've had a lot of issues come up here involving, of course, divestment, but also involving what some people might consider social considerations. You've heard from various parties about different things. So I thought it might be useful to at least show you how, even though you're not covered by ERISA, how the U.S. Labor Department looks at social investing and the kinds of questions that need to be asked and the kinds of challenges that you face if you have interests other than just, the investment interests, which you're allowed to do. You know that because I've talked to you about that in the past, but how you go about balancing that. So, but first I'll just give the straight lecture as I go. Your authority comes from the Constitution and the statute. And that's not true everywhere. A lot of states, it's just statutory. But, you have strong language in the state constitution granting you authority. And that's why from time to time, when the legislature attempts to do something, Brian and I can tell you, well, it's, of course you have to pay attention and can't just, ignore the legislature. But there are going to be occasions where the constitutional language that grants you authority over the system requires you to be prudent and act solely in the interests of members of the system may trump what the legislature has enacted and the governor has signed. Hopefully you don't run into that very often because obviously politically that could get ugly, but you have constitutional protections, the members have constitutional protections here in California that are not true everywhere. So, the language in your statute is word for word from ERISA, so we look to ERISA for guidance, not for absolute adherence. There is room, to interpret things, based on the California situation and California law, but the body of law in the Ed Code that applies to you is taken word for word from ERISA, and I think that's an advantage because ERISA has been, in operation since 1974, and there are Labor Department rulings, there are court decisions which give us guidance. And we could give you advice. Yes?
I see you turning pages,
Oh, isn't there?
but this is not moving.
Oh,
The I don't know if
Am
you
I
need
supposed to do that? Is this it?
I don't know.
Okay.
It looks like it could be.
Nobody taught me
Yeah, it's the
anything.
button on the right that arrow.
This one?
Yeah.
Ah, all right. Okay. Well, fortunately, I didn't go through very many.
There.
Okay. All right, so I said that. Okay.
right.
So a trustee is held to something stricter than the morals of the marketplace. You've heard me say this over and over again, that as trustees, you have the highest duty known to the law, higher than corporate directors and officials, higher than union officials. Being a trustee of a trust puts you at the very top. So, and through the years, the boards here have had no trouble understanding that and adhering to that. You're not covered by ERISA, but you're covered by the Internal Revenue Code. Internal Revenue Service really hasn't paid that much attention to public plans through the years, but there's always the possibility that they might get interested in a particular issue. You are required to be administered as a qualified plan. You are qualified. You have to comply with the exclusive benefit rule, which is really no different than prudence and loyalty. and you can't engage in a prohibited transaction. And the only prohibited transaction in the Internal Revenue Code involves using plan assets for the benefit of the state and the employers who sponsor CalSTRS. But you're covered by other prohibited transactions provisions in the Ed Code, which I'll talk about briefly later in my remarks. So the first duty, the two duties are prudence and loyalty. I'm not going to talk much about prudence today, but you know, it's all due diligence. You've heard me say it's not if you win or lose, but how you play the game. If you're careful, if you rely on your experts, even if a decision goes in a negative direction and you lose money on a particular investment or even an entire class of investments, if you've done your due diligence and had your staff and consultants do their work and you've listened to them and evaluated what they're telling you, for the most part, you're going to be safe. The words that are care, skill, prudence, and diligence. This is sort of just bullet points. You're supposed to act with a degree of skill deployed by other trustees of plans of a similar size and nature. You're not required to follow their lead. You aren't required to engage in what some people describe as herding, where all the different public plans do exactly the same thing. I think maybe I told you last year, for a long time, CalSTRS was not investing in hedge funds. Another client of mine, Texas Teachers, was probably the biggest investor in hedge funds in the country. I was able to give both boards the opinion that they were being prudent because both boards were doing their due diligence in deciding, how to invest plan assets. From time to time, you're going to need expert assistance. You're not supposed to blindly rely upon your experts, but if you don't rely on what your experts tell you, then you do have the burden of demonstrating why you're not following your experts' advice. Good faith is no defense. You're governed by the whole portfolio rule, which creates room for you to take risk within the portfolio. When I first started representing STRS was only invested in bonds because at that time investments in stocks, equities, was considered speculative. So there were no investments in stocks in the 80s until I served on a commission that Governor Brown established and the legislature established at that time to change the law to bring it into the modern age, and that's when we brought in all of the ERISA language. And one of the very good things about that is the whole portfolio, and that enabled CalSTRS to make a lot of money through the years investing in private equity and real estate. And then you're required to diversify the investments. From time to time, this board has heard advice telling it that you can invest, for example, up to 50% of your real estate portfolio in California because Northern California and Southern California are so different. So that's diversification. Well, we learned in the 80s and 90s that really wasn't true when the real estate market crashed, and it crashed all over the state of California. And that's one of the reasons why your staff and consultants now bring investments to you from around the country. You're allowed specifically to delegate authority to invest, which you do, to both staff and outside investment managers. Once you do that, you're protected against liability. Your only obligation is to prudently delegate, so to make sure you're comfortable that your staff is qualified and that your consultants are qualified, and you properly monitor the delegation. And we've talked through the years about what proper monitoring consists of, and I've laid the burden on Chris Ailman and his staff to provide you with loads of information about investment decisions that they've made, which are available to you on the website, only available to board members, which I hope you look at now and then so you're aware of what's going on. But that's the kind of monitoring that prudence requires. And I just want to remind you that corporate governance is covered by the fiduciary rules. So you do have to be prudent. You do have to follow the loyalty rules in corporate governance. the same way that you follow it with straight investments. When you vote proxies, when you become more active, all of those are, you have to weigh the cost and benefit of what you're doing, and your staff is very good at that. And when you have your meetings where your staff makes its presentations, they do a good job, in my opinion, of going through what they need to go through, so that when you make a decision, we can be sure that it's a prudent decision based on the right, the appropriate considerations. The second duty is the duty of loyalty. It's the one that is much more difficult to figure out, much more difficult to apply. I spend a lot more time with my boards on the duty of loyalty than the duty of prudence or anything else. Conflicts of interest are also included under duty of loyalty, so that's also one of the reasons for that. So, under the Constitution, you have the duty to act solely in the interest and for the exclusive purpose of serving system members, providing them with benefits, and defraying reasonable administrative costs. While performing your business here, you can only wear one hat. So if you're elected by the union-affiliated members, or you're representing, like the finance office does, the administration, or those of you who represent the treasurer or the controller, you can wear your hats in those capacities when you're outside of this boardroom. But when you're here, you're only representing the interests of the members of the system. And I guess that also goes for the public members, who obviously have outside interests. All of you here are only supposed to be interested in the interests of the members of the system. Not always easy to tell the difference. Most of the time you're not even going to have a potential conflict or any kind of problem. But I'm going to talk today about some of the situations where there might be problems, and you just have to be aware of them. You have no duty of loyalty. This sounds harsh. I've been accused of this slide being harsh. You have no duty of loyalty to the legislature, taxpayers, the union who appointed you, or those union members who elected you, the governor who appointed you, or contributing employers. So as I said, I'm going to take time, a little extra time today to talk about ETIs, or economically targeted investments. And these are transactions that take into account non-economic investment considerations. When ERISA was first enacted, the Ford administration administered the law for the first couple of years, and they took a very hard line against consideration of non-economic factors. They issued some rulings where they took the position that you couldn't even consider, if you're a fiduciary under ERISA, you couldn't even consider non-economic factors if you made an investment and it looked to the Labor Department like you might have considered non-economic factors, say union jobs, perfect example, then the burden was on you as a fiduciary to prove that it played no role in your decision making. We changed that in the Carter administration. But we didn't change the basic idea that all decisions have to be exclusively grounded in economic considerations. You're not required to invest in everything, or or in anything particular. I already talked about, your predecessors not wanting to invest in hedge funds. But if you're not going to invest in certain investments or a certain class of investments, it can't be because of the non-economic factors. The economic factors require you to consider everything and then decide, what is prudent economically and financially and investment-wise before you're allowed to think about other non-economic factors. So the investment is not appropriate if it provides the plan with less return in comparison to the risk involved in comparable investments, or involves a greater risk to the security of plan assets than another investment course or course of action offering similar return. Now, the exception we created is the everything being equal test. You've heard me talk about it. And when you're considering two investments of that involve non-economic factors, you have to make sure that the two investments are comparable based on risk and return. If that's the case, then the non-economic factor is considered incidental to the economic-based decision, and it's considered prudent. So it's lawful for you to take it into consideration. Again, union jobs is the one that faced us in the early years of our administration of ERISA. The Labor Department has issued various pronouncements since 1981 with respect to ETIs. Again, they're not binding here, but they're helpful and they're useful, and we would expect that, if there's ever litigation, that the courts, would look to ERISA precedent because it's really the only thing out there. And there is this body of law, and for the most part, the body of law has been favorable. And I would say today, most lawyers would agree with me when I say that ERISA plans and public plans may prudently take ESG factors into account when they're making their investment decisions. And that's something that certainly wasn't apparent when ERISA was first enacted. I want to talk a little bit about a Labor Department bulletin that was issued in 2008. It builds on one that was issued in 1994 and with some of the things we said at the Labor Department as early as the late 70s. But the reason I wanted to talk about it just a little bit is because it contains concrete examples of how the federal government looks at this. And through the years, Chris Ailman has teased me a lot about everything is equal, how do you apply it, what does it mean? So this gives a little bit of guidance as to at least the federal government's thinking about it. The first example is a situation where a plan owns an interest in a limited partnership that is considering investing in a company that directly competes with the plan's sponsor. So obviously, that's something that the sponsor of the plan and the fiduciary of the plan isn't necessarily going to be happy about. The Department of Labor analysis is, well, that's too bad. This is a factor that's outside the interest of the plan. Again, you have to only look at the interest of the plan. So the plan may only replace the limited partnership if it finds an alternative limited partner investment equal or superior based on risk, return, liquidity, and diversification. We had a situation this past year with a pesticide where your staff consulted with the general partner of the limited partnership and fortunately was able to persuade them that it was in the interest of the limited partnership to get rid of that particular investment opportunity. So you weren't faced with the decision of whether you could replace the limited partnership altogether. And, I have to, remind you that the relevance of this holding is we have had discussions through the years where you've had limited partnerships where general partners have invested in privatized public services. And so this provides some guidance. It's not that easy, even though it seems like, as a matter of common sense, that, your limited partnership shouldn't be invested in, ways that directly compete with public schools, for example, or other public sector jobs. The law requires that you jump through legal hoops if you're going to consider somehow changing your investment so you don't have the embarrassment of being invested in those kinds of investments. Next one is a multi-employer plan that wants to invest in a large loan for a construction project located in the same area because it wants to create local jobs. This time the loan carries a return that's commensurate with the risk, with a return commensurate with other loans and with the risk of non-payment. The problem is that the plan has already made several other loans in the same metropolitan area, and the Labor Department says it's not prudent to make that investment because you're potentially violating the diversification requirement, and when you weigh all the different factors, It's because of that, the investment is not of equal value to other loans that might be made in other geographic areas or other investments that the plan might want to make. So everything there was equal in terms of risk and return, but because of diversification problems, it's not a prudent investment. This is a plan that's considering investment in a bond to finance affordable housing for people in the local community. The bond provides a return at least as favorable as other bonds with similar risk, same sort of situation. But this time, the bond size, it's a giant bond, and its lengthy duration raises a potential risk regarding the plan's ability to meet its liquidity needs. Other bonds do not pose that risk. So again, the Labor Department is saying this investment is not prudent. Again, even though it's, risk and return is okay, because it raises a potential problem with liquidity needs, it's not a prudent investment. This is, one you're going to like. It involves investments in environmentally friendly companies, green companies. And in the hypothetical that the Labor Department poses, the plan fiduciaries decide that they not only like green investments, they love green investments. So they're only going to invest in green investments. Well, the Labor Department said that's not prudent. It says the plan must consider all companies that meet the plan's prudence criteria, and it may only eliminate companies from consideration if it can prudently determine they can be replaced by investments that provide equal or better returns at the same or lower risks and would play the same role in the plan's portfolio. So this, I view this as sort of a divestment hypothetical. The idea being that this plan didn't want to even consider investing in, say, the U.S. oil industry. And I recently reviewed a draft prepared by an association with which CalSTRS works closely in the environmental area. And when I read their legal analysis, I thought it was subject to interpretation of exactly this, that it was basically telling plans that they could avoid investing in the oil industry because obviously you can't characterize the oil industry as being green. I talked to the general counsel. I convinced him that my concerns, and he rewrote the language in a way that I found was perfectly appropriate. So I was happy it was sent to me. I was happy I caught it, and I was happy he agreed with me, because I would not have liked that to have been out there in the public realm, and for CalSTRS to have been along with other plans, to have been associated with that that our possible interpretation of what CalSTRS is up to. So that was a very instructive hypothetical that the Labor Department provided. And then finally, this is a union-related hypothetical. I don't recall if CalSTRS is invested in any of the real estate funds that say that they're only going to invest in union projects. I know the Taft-Hartley funds, for obvious reasons, particularly the construction Taft-Hartley funds, are very heavily invested in those kinds of funds. Well, what the Labor Department is saying in this one is, even though you can make an investment in that kind of fund initially, because you can assume that the risk and return characteristics are going to be equal under the everything is equal test, you're required as an investor to monitor that fund. And if you have a sense that the general partner of that fund is not going through the rigorous due diligence that's required under the everything is equal test to make sure that when it invests in a union project, that it's comparable to a non-union project, then you have the burden and obligation to raise that with the general partner. And the Labor Department says that that fund may be required to invest in some non-union projects. As a matter of reality, I would say good luck. But at least that's the theory, and that's the way the Labor Department interprets the law. So you just have to remember, with these 5 hypotheticals, that when I come up here and tell you things, I'm not making it up. I mean, this is the way the federal government looks at this. We don't always have to be as strict, and, every situation, has its own, characteristics, and there's room to play with them. But the bottom line still has to be always that economic considerations have to be the only considerations that are behind the making of the investment. I won't talk much about divestment because we've really been talking about that a lot, but you know the questions, you know the rules. What I like about it is we've done it so many times now that we don't have to reinvent it every time a divestment is raised. What I did want to mention, though, because I had to address it when I wrote the memo that I believe you received on gun divestment, is that the risk factors play a role now in the divestment process. As I pointed out in my memo, first of all, the risk factors now help your staff and consultants and you identify potential divestment targets, because to the extent that some of those risk factors or all of them are violated by certain investments, it now brings them in, forward, and you think about them as, as something, well, maybe we shouldn't be in these, either we shouldn't be in them in the first place, or maybe we should divest. And then the second place it comes into play is when you're considering whether you could satisfy the everything is equal test, because the risks that are identified in the 21 risk factors, in my opinion, can be taken into account when you're comparing, one security against another or an industry against another. You could add this risk from your risk factors to the risks that you use in comparing risk and return. So it's a handy tool, and it's something that I welcome. And when we looked at guns, we had never used that before, on Iran or Sudan or anything else. But with guns, it was available, so we used it, and I think it worked very well. The Constitution has a third exclusive purpose requirement, and that's to minimize employer contributions. So it's something that obviously you want to be aware of and cognizant of. But it also clearly says that that's secondary, that your duty to participants and beneficiaries takes precedence over any other duty. So you're allowed to think about it, but it can't be your primary consideration when you're deciding what your key objectives are. But it gives you a little bit of room to work with the state and the employers. So I think that's something that's welcome. It's interesting to me. I don't know who thought of this and put it in the Constitution, but it was someone who knew their pension law. So I thank whoever it was. You also have a duty not to engage in certain transactions. This is taken from ERISA, word for word, with system members, with an employer, as I said, and involving self-dealing. With system members, it's just a question of adequate consideration, sale or exchange, leasing of property. I don't know if any of this is ever even done. No one's ever asked me about this in all these years, so it's probably not even worth talking about, but I just wanted to mention it. Yes, go ahead. Sorry, Rich. Yeah, that's the way the legislation reads.
Okay, so
So we're not supposed to give a benefit to a system member other than the benefits they receive, as pension benefits.
Is that a benefit from the board as a whole, from the organization as a whole? My sister's a retired teacher.
Okay.
I enter into an agreement to buy a vacation place with her.
Oh, no, well, that's your other hat.
Okay, all right. I just want
That's your
to.
brother has.
Yeah,
Right,
Mike
as it
DeRay,
reads
you
here-
talk Mike DeRay into investing in that.
I got it.
cover.
As it reads here, it's any system member. So I just want to.
Right.
Okay.
Transactions with an employer, this gave us a lot of aggravation for a long time because there's an absolute ban on acquiring any employer security, real property, or loan. So twice in history, the board has decided to go to the legislature to get an exemption. So once it was for credit enhancement, so the staff wasn't limited to doing credit enhancement for everybody else, but couldn't do it, for employers. But we added, remember I talked about the Internal Revenue Service, we added as long as it complies with the Internal Revenue Code. And then in 2002, we did another one for planning, developing, and acquiring surplus real property owned by school districts. So that was another example. And again, we said as long as it complies with the Internal Revenue Code. And as far as I know, we're doing both prudently, and staff has not had difficulties complying with the Internal Revenue Code. So it's a good example of where where the board has exercised its duty in a positive way. Under ERISA, the Labor Department could grant exemptions. You don't have that. You can't go to anybody for an exemption. So in a sense, that's what the board did in these two situations. It had an absolute prohibition, and the board created the exemptions, and the legislature enacted it. So it was, both of those, I think, worked out very well. Transactions involving self-dealing. Thank goodness, in all my time here, I've never had an issue, with the boards at CalSTRS. Obviously, there are other plans where you've had problems. Oh, I'm sorry, I keep forgetting. I'm not good at this. I need help. Okay. All right. So you can't. There are three. First, you can't use the system's assets in your own interest. That's pretty obvious. But again, under ERISA, there have been years of interpretation and application, so it's helpful sometimes. But obviously, if it can affect your best judgment as a fiduciary if you have an interest in an investment. I was hired initially right after there was a scandal at CalSTRS. I don't know if any of you are familiar with it or old enough to remember it. At that time, there was a three-person board, and it was just when CalSTRS started investing in things other than bonds. And the controller was on the board, and I think the treasurer, I don't remember, there was another public member, and then there was a so-called investment expert. Well, it turned out the so-called investment expert used his influence on the other two board members to get them to agree to invest in a property, and he never disclosed that he had a personal interest in that property. And it became sort of a cause célèbre here in Sacramento because he apparently was seen driving out of Sacramento after the investment was made in a convertible with a blonde woman sitting next to him. And so it became like a legend. He was driving to Mexico. And they brought him back, and he was, indicted and convicted, and I don't remember his name. But that was a perfect example of, acting in your own interest. And Ken Corey, I don't know if you remember him, was the controller at the time, and it really damaged his career, I think, I was told. So he was a good guy. So he was duped. The next one is acting on behalf of an adverse party. And this is one that sometimes comes into play with the gifts, the receipt of gifts. If the gift is, I'm not going to obviously get into gift policy today, but if the gift is big enough so it looks like, it might not, influence a particular decision, but it might make you a little bit friendlier towards a vendor or someone working for a vendor. A vendor is definitely an adverse party. So, you have to think about whether you feel comfortable voting on something involving that vendor, even though all the gain is for the vendor. It's not, you're not getting anything under this particular prohibition. The next prohibition is the one where you would get something, which is the bribe or the kickback. Under our interpretation of the law, although the statute doesn't say this, if you feel you can't vote for something because you believe you have a personal interest, or you believe you can't vote because a vendor, possibly, is a friend of yours or gave you something, you can recuse yourself, and that's a protection. So, you don't, when I was at Texas Teachers, the staff was interpreting Texas law to require anytime there was a conflict like that, the board member had to resign. and I convinced them that no recusal, should be available. The board embraced that. They preferred my interpretation. But you can't recuse yourself from a kickback, because a kickback, you're, receiving something knowing that you're receiving it because of someone's trying to influence you. Okay?
Actually, no, it's a question that actually is more to process than substance. On the recusal, is it necessary to explain the purpose of the recusal?
The Labor Department, and I have that on the slide, the Labor Department only recently, for the first time in history, said that there may be situations where the person who recuses him or herself has to disclose to the other board members. They called it material information. It's sort of a ambiguous term. The situation where they said that involved a board member who had actually received, I think it was a trip to, play golf in Scotland or something, from a vendor, and he recused himself, but the Labor Department concluded that that was material information that the other board members should know about, that they were being asked to hire a vendor who was who did something like that. So that's sort of a case by case. Frankly, I prefer the disclosure not be made, because I think it makes it easier for people to recuse themselves. It's it's sort of like public confession, in a public meeting to announce that you got this big trip or a campaign contribution in the old days or whatever from a vendor. So, but it's something that'll be done case by case.
I'm sorry, Matt. Just add that there are FPPC rules that we also follow on recusal. So outside of the fiduciary considerations, there are sort of processes and procedures on how to recuse yourself, and that's something that the General Counsel and the Ethics and Compliance Council would assist with. So, and I'm going to talk about it
And we would work
next.
together on things. It's two separate statutes, and I worry about the ed code, and and Brian worries about the other. So
And we both worry.
it works together. We both worry a lot, but not at this. I don't worry at this fund. I don't know if Brian worries. Okay, receiving kickbacks. I mean, it's hard to prove, but that's that's about the worst thing you can do. We like to think that that courts would look at de minimis gifts when they're evaluating whether something was given with the intent or the expectation that it was a kickback, but there's no guarantee of that, and that's why receipt of gratuities makes me so nervous. I'm not going to talk about it too much because I didn't realize we were going to have such a long discussion of the gift policy yesterday. There are there's a lot of guidance at the the Labor Department, and what we've learned at other plans. Every year, I like to talk about the poor former teacher trustee at Ohio STRS who was indicted and convicted of a misdemeanor when she went to New York and attended a dinner. I think she brought her spouse along, and I don't remember who the Wall Street firm was. They took her out to a somewhat fancy restaurant, and I think the bill for the four of them was like $500. It turned out $300 or so of that was spent on an expensive bottle of wine that the two investment bankers drank. She and her husband didn't drink. She was told by general counsel of the fund that it was okay for her to attend the dinner, and by the executive director, because it would save Ohio STRS money to have the vendors pay for the dinner. But I guess I would say an ambitious prosecutor prosecuted her. I don't know how he found out about it. And a jury found that she she committed a misdemeanor. I always, remind boards, people who serve on juries a lot of times, are relatively poor. They haven't, traveled a lot. stayed at, nice hotels, had nice meals, and, one of the beauties of ERISA are there's no jury trials. But in state law, you would face a jury, and you never know. It's impossible to predict what the outcome would be. One of my biggest worries, and I think the gift policy that Brian drafted took care of it, and I haven't, obviously have yet to see what the new one's gonna look like. But the one that worries me a lot, is the one where you're in business, or, you're a union officer, and, you, in that capacity, those capacities, you receive gifts, you attend, meetings, you get lunches and dinners. It just always worries me, again, the two hat, how do you tell which hat you're wearing? And how do you tell, it's not always so clear, why someone is giving you something or buying you something. So it's just something that, that I worry about, an accidental conflict. So I just, always encourage you to think about how something would look and, whether it's just the safer thing to do to recuse yourself. I don't want you to recuse yourself all the time, obviously, because you have, obligations, but sometimes maybe it's the smarter thing to do. Non-investment related duties, the same rules apply to those. We've talked about this, a lot, potential benefit reductions. They're not considered fiduciary decisions, they're plan sponsor decisions. But of course, you're asked to comment and perhaps take a position on legislation. So it could create difficult potential conflict positions for some of you. And I haven't seen much, if any, evidence in this board that people aren't aware of what hat they're wearing when they're talking and voting. But, accusations will be made, and you just have to be sensitive to, the potential conflict, because obviously, if you're representing the workers, you're representing the state or employers, on the outside, you have different interests, arguably. I came up with this last year because there were so many questions about trustees. In a nutshell, trustees may be permitted to support cuts, but in my view, they're not required to do so unless the actuary advises it's necessary to protect the soundness of the plan. And trustees are not required to oppose benefit cuts. So there really aren't requirements either way. Everything is situational. Trustees, a lot of times, especially when there are a lot of labor organization members, ask me, are they permitted to oppose benefit cuts? And again, I think it's limited, but I gave some examples of where I was comfortable telling the board that they could oppose. In New Hampshire, where all the legislature did was cut member benefits to help employers in the state of New Hampshire save money without doing anything to improve funding. In Ohio, where the board came up with proposed cuts, which the actuary approved and which would have saved the fund a lot of money and achieved actuarial soundness according to the actuary, but the Republican legislature introduced legislation that went far further than that, draconian legislation. And then the cuts can't discriminate against retirees versus members and that sort of thing. You have to be careful about that. Claims processing, you have to treat similarly situated participants and beneficiaries the same. One of the biggest problems I have with boards is, board members a lot of times are good-hearted. They want to do justice. They feel sorry for the person who's doesn't qualify, so they come up with, some exception and I get in fights with them, and sometimes they go ahead anyway, and then it always winds up, I don't come back and say I told you so, but it always winds up with me being right, because then other people come in and their lawyers discover it, and they try to take advantage of the same the same decision. Okay. Need to follow the terms of the plan, only pay benefits that are allowed, and to make reasonable efforts to collect overpayments. Duty to limit expenses, you do that already. And then finally, liability. And again, remember you have a special provision in the Ed Code that no one else has that I'm aware of. It's been in there since 1990, and it protects you against liability for violations of prudence and loyalty and diversification. So the only thing you're potentially liable for under the Ed Code is engaging in the kinds of prohibited transactions I've talked about. And also for gross negligence or fraud. The term gross negligence makes me nervous, but so, you know, that's one of the reasons I believe so strongly in fiduciary insurance, if you can get it. And then there's an exception for breach of fiduciary duty in connection with the administration of the plan, which there's no legislative history. None of us know what that means. But there, too, you have potential liability. Co-fiduciaries, you got to pay attention. Obviously, you can't participate or conceal a breach. You can't enable the breach. And if you have knowledge of the breach, you're supposed to report that either to your executive director or to your general counsel, I believe, under your policies. So that, you know, that's something you want to obviously avoid. Again, if you prudently delegate to outside managers, you are not liable for the decisions they make in making their investment decisions. Finally, fiduciary insurance, you're required you have it. You know, we can discuss that at another day, but I just wanted to, you know, remind you that you are required to have it. It's not something that you decided to, you know, to buy out of your you know, own discretion.
All right,
Okay, well, thank you.
thanks, Ian. Are there any questions for Ian at this point? Thank you very much, Ian, we appreciate it. Brian, it's to you for ethics.
Does anybody want to shake out the lawyer before I go back up here?
Come on up.
Yeah, maybe more grass and.
Good afternoon, board members.
Good afternoon, Brian.
I'm joined by Joe Lukens, who I hope you all know is our Ethics and Compliance Counsel. And since we're talking about ethics, I thought it would be a good idea for her to provide any additional insight or answer any additional questions, especially those that I don't know the answer to. So let me put you all at ease. First of all, I am not going to discuss jury trials. I am not going to discuss liability, and I'm not going to discuss insurance. You know, between the board governance items that we did, that you worked on yesterday, and your fiduciary liability lecture that you just had for the last hour, I tip my my general counsel hat to all of you. You have a really hard job. There's a lot to keep in mind. There are a lot of statutes. There are a lot of rules. I think the beauty of it when you talk about ethics is what is your guiding principles? And from what I know about this board historically and from and this group in particular, is that guiding star helps you get through all of these difficult and sometimes complex rules. And I didn't want to spend too much time on this, except I wanted to, and I'm happy to answer questions as we go along. A couple of things I really feel like we need to get out on the record. It's called ethics training. That's what we refer to it, but it's really an ethics discussion. I mean, on some things you can train people on the rules, but ethics is really a mode of operating. And as I said, this particular group, I think it's just, for us, it's a reminder and a discussion. And then I wanted to, we're speaking about ethics. Yesterday, Nancy Williams was using a great hypothetical, but it started off with, what if a law firm wants to take me out to a dinner, $300 dinner to find out how to get more business from CalSTRS? And the first thing I would tell them is, don't take me out to a $300 dinner. Let's go get Chinese food. I'll pay my own bill, and then we can talk. So, and I know you all would answer the same way. It's just sort of, okay, immediately your own sense of, okay, this is not right. This is something we need to talk about. I give, as I did last year, I provided this framework for ethical decision making. It's sort of, I think most of you do this sort of innately. I do think that one of the things that very often comes up in ethics conversations is, what would your mother think about what you're doing? What would it look like on the front page of the paper? What would your spiritual advisor think about what you're doing? But very often, because you're in a political situation, it's really, what is the public perception? And the only thing I'm going to, and I think this is really important to keep in mind, is optics is not ethics. So I think that's important as you sit in these chairs. That, very often you have to consider optics, but that's not ethics. You have a lot of rules. I'm going through the board materials first, and you'll see that, it's in your board policy manual, but you see on page Board Education 20 and 21, you have a statement of ethical conduct that is very comprehensive. It is, in addition to all the other rules that you have decided upon yourselves to adopt a very stringent statement of ethical conduct. And it talks about use of prestige, facilities, confidential information, accepting money, performance of an act, knowing that it may be subject to the enforcement of such person or by CalSTRS, receiving gifts, having ex parte communication, making any statement that purports to be on behalf of CalSTRS that is not. And then you have board member responsibilities I've listed some briefly, also from your board policy manual, that sort of talks about your individual responsibility as board members. How you have to attend the meetings, you have to expected to perform service for the committee, prepare for the meetings, which I think when you have over 1,000 pages of board materials is no small task. The collegiality, you even have sort of an internal rule that you're, and I've always seen you exercise it, that you're going to be nice to each other, avoid the appearance of nepotism and independence, and then you have a pledge on top of that. So it is a lot, and then also you also have a code of conduct that you affirm. So you've already provided a framework internally in existence to the FPPC, in addition to the FPPC rules, in addition to any of the government code rules, in addition to your fiduciary responsibilities. So there is a lot that applies to board members, and so it really is, when we talk about ethics, I think it really is, we should talk about amongst ourselves what sort of ethical underpinnings or what sort of principles to follow. And for those of you who've been here more than a year and a half, you might have seen me talk about Kant's critique of practical reason, but yeah, I decided that we wouldn't do that this year because you're following on fiduciary. I think you'd probably kill me. So we have the Political Reform Act. There's it's again on conflicts of interest, and as I mentioned when Ian was talking about your fiduciary duty, as plan trustees, there are also other things that go into that mix besides just general conflict of interest. You have conflict of interest from the government code, and as Form 700 filers, there's some, there's some guidance on what you should disclose and how you should disclose it. There's a disclosure requirements. I'm going to go through this pretty quickly because we covered a lot of this in our gift policy discussion. The limit is $440, as I think Jill mentioned. It's pretty high. I think was it the highest in the country or one of the highest in the country?
I believe it's the highest.
The highest. The amount, a single source annual limit on the FPC is high compared to other states. And then there's the disqualification. There's an 8-step decision process. If you have any questions, please call Jill or myself, and we would be happy to walk you through all 8 steps. I assume there's no objection if I skip through these steps. I will be happy to provide it to you in writing. Common law conflict of interest. These are, a financial interest, but it's from personal interest and not a board member's philosophical outlook, and I think that's very important, especially as you get into these debates that there may be activity that's happening, and you may be philosophically opposed to it, and you may express that. That's not a conflict of interest. Conflict of interest is not disqualifying. It's just if it's towards a particular party. In other words, if your philosophical interest is towards a particular group of beneficiaries or particular folks that can have a positive outcome or negative outcome from your decision, that's not the same as sort of having a philosophy such as fiscal conservatism. That's not the type of thing that's a conflict. The Government Code Section 1090, that was kind of a big deal coming out of San Diego. Basically, board members voting on a contract in which, or a decision in which they ultimately have some interest in the outcome and benefit from the outcome. But that was clarified by the California Supreme Court, so particularly as to members of the CalSTRS pension plan who are making decisions on the board, if the board members make a decision that results in a possible advantage to the CalSTRS members, if it's the same advantage to all the rest of the CalSTRS members, that is not a conflict of interest, and it doesn't violate Government Code Section 1090. Honest services fraud, this thing has kind of gone away, but it was a very interesting concept, and I'd be happy to talk to you about it. It's the Schilling case. It's very fascinating, and Robert and I used to discuss this for hours, but I think I can probably remove this slide because it doesn't relate to, it doesn't really apply. It really has to do with bribes and kickbacks. No contact policy. I think this is something that maybe we should spend a little time on because this is not something that we've covered so far. Once we go into a procurement process, there shouldn't be any contact between the prospective bidders and the board members. And so, and then we have a policy if there is, it's to report any prospective contact, any contact with a prospective bidder. So it is the kind of thing where, let's say the ABC Technology Company is going to bid on our pension solution, and they call up a board member and say, "Hey, Brian, how are you doing?" I just elevated myself to the board, but I didn't want to use anybody else as an example. Say, "Hey, Brian, how are you doing? We've got these really great products out there, and we're really interested. And we think pension plans will be really greatly served by this, and enthusiastic clients, and we'd like to come out and talk to you about it, or we'll send you a brochure." And you find out immediately thereafter that we are going through an RFP process. That's the kind of thing that should be reported, and should be reported. If it's a contract, it should be reported to the board or the CEO. Undue influence. This is one of those terms that as a lawyer, I could put my kids through college trying to define undue influence. It has sort of a term of art. Usually it has to do in other situations, but this is where there's pressure put on a board member by third parties to seek action or a specific outcome. So we do see this occasionally because you're all public figures. Many of you are involved in different areas of business, and there are, people may contact you if you're a teacher member. You may be contacted by a teacher on a particular issue, and so we have an ex parte communication policy, but it's also, anyone who's trying to twist your arm or make a decision. And again, if any board member feels that they are in that position, they should report that to the chief executive officer or the general counsel, and I'll work with you on it. Campaign contributions, we have our own campaign contribution policy and regulation. This is one of those, Michael, I think you asked about recusal. This is recusal required if more than $250 in a calendar year. And the recusal would require disclosure of the recusal, why recusing. Investment relationships, this is, campaign contributions, and I know I very often work with folks on the board if they have questions about these. But if it exceeds the limit, there's recusal. There's also on the other end, the proposed business partner may be barred from doing business with us if they exceed those limits. And that's happened quite a few times. We go through a process and review, but eventually we send them a note and say, I'm sorry, you can't do business with us because you've exceeded this particular rule, and it goes on. It lasts for 2 years. Insider trading, we'll be bringing that back to you. No honoraria. Public Records Act, happy to go through that with you. These are, as I'm going through this reinforces what I said, that you are operating within a great number of rules that provide, very restrictive, and so it's our job to help guide you through that. And Bagley-Keene has its own requirements. California Constitution has something on travel. So at the end of this one, I wanted you to know if you have questions, you know Jill, and then senior legal analyst, ethics and compliance analyst is Tiffany Vincent, who you all have probably met, especially if you haven't turned in your Form 700 within the appropriate time frame or expected time frame. We do have a CalSTRS ethics hotline, and it is available to board members as well. I mean, it's certainly public and staff, but if a board member sees an ethics violation, of course, I would, certainly the Office of Ethics and Compliance and General Counsel, we are here to address that. But again, if there's if a board member feels a need to make an ethics complaint or file something ethics, the hotline is available to board members as well. There are quite a few rules. I hope I haven't belabored them. I'd like to sort of, if you before we get to any questions, is get to if you look to Board Education 26 and 27, they're sort of guidelines for ethical decision making. And as I said, there's no right way to do a wrong thing. I think that's and I do think most people, and certainly all the people on this board, what the right thing is. You can hear your third grade teacher telling you what the right thing is, or whoever had an influence in your life. Honesty is the best policy. The easy way can be the wrong way. I know that, and I don't mean to insult anyone's intelligence or sound patronizing, but it is these things that you have internalized that provide your ethical guidance as you navigate through these rules. Is what you're doing make sense? And I think in the day-to-day tumble, especially in board meetings, maybe I hear that discussion come up. Why are we doing this? Is there something to fix? Is it broken? If what you're doing is questionable and you're prepared to accept the consequences, again, I think that's pretty basic. Are you conducting your business in a way in which you would not be ashamed? And I mentioned that. If your mom or somebody else found out what you were doing, would you be in trouble? If this one is number 6 is if you don't have something good to say about someone, don't say anything at all. As someone who grew up in New York, I have a real problem with this one, especially when I'm driving. I don't think I ever yelled out, "Wow, what a great driver!" But it's always a good rule. Are you honestly and accurately presenting all the facts and to your business partner and to the public? Are you providing the same service, same level of service, and in your case, the same level of access to all? And are you fulfilling your duties? Obviously, this is adapted from a sales approach, but are you fulfilling your duties to the best of your ability? And then again, this is sort of this is back to the optics. Many people do use this as a touchstone. It's if your actions were published in the local press tomorrow, would you be able to say you did the right thing? I appreciate that, and I know the atmosphere that you all operate in. But again, I reiterate that optics is different than ethics. That very often you have to make decisions about optics, but the underlying decision should be ethical first. Appreciate your patience as I walk through both a written piece and a slide piece that do not match. So I'm here to, and Jill and I are here now or afterwards to answer any questions.
All right. Thank you, Brian. And having the written and the slideshow different, that's a good thing.
Oh, thank you.
John? Terry? Sorry, I just read that. I was like, oh, okay, John's here. Oh, no, he's not.
Thank you. Brian, in the disclosure section of the board website, there's a number of items, the list of current contractors, investment and non-investment, and so on. And like 3 out of 4 of those have sort of a date on them. I assume the last time that they were updated. One of them doesn't. I'm not quite sure when it was updated. But how often do those get updated, and is it done by your office or some administrative area? I'm just kind of curious.
So for ease of getting you the information, I'm going to ask. And so for the ease of getting you the information you're asking for, I'm going to answer the second one first. No, my office has nothing to do with updating that. And then I'm going to turn behind me and see who's ready to answer the first question.
Jack pointed to you.
Which page are you talking about?
I could probably answer it partially.
Yeah, I believe that Robin is here to fill in the blanks.
Perfect.
As usual, Robin's always got the perfect
That was
answer.
good, because Jack did point to you. That was good.
So we provide that information with the collaboration from investment staff and other people actively working on procurements. So
Okay, and how often does the no contact list get updated?
it is a monthly process,
Excuse me?
a monthly process
Okay.
at this, that's our,
Gated on the document.
So there should be a date on that
Mary
one,
loaded
right,
them for you, but
yeah.
what if you get the
Okay. Thank you.
So Robin, it sounds like Terry had seen one that didn't have a date on it. Could you check into that to make sure that happens?
I'll make sure they're dated.
Thanks.
They should be dated. So I think there's an as of date at the top, but I will definitely check, Terry.
Okay. Are there any other questions? Brian, that's it for us. Thank you. Thank you, Jill. Unless you had something to add to what Robin said.
2012.
No, I thought maybe he was asking about the form, the 600H or J, so.
Yeah.
All right, thank you very much. The board is scheduled to start at 2:30. Let's go ahead and take a 10-minute break, and we'll start at 2:30.